Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Sorry about the blinds right there, where we're going to try to get a better video shot. It's the middle of the afternoon. This is typically when I do not shoot videos, but we got some huge news to announce today. Obviously, you guys may have already heard about it. The pistol brace rule, at least for now, is dead. Now, I'm going to get a little emotional, a little verklempt here, because many of you hopped aboard the Washington gun law bandwagon during the trials and tribulations of the pistol brace rule. I think that we probably have covered the pistol brace rule as much as any subject that we've covered here at Washington Gun Law, and I would venture to guess that we've probably covered the pistol brace rule as thoroughly as any channel out here. That being said, it appears that this rule is dead for now, at least. So let's go through the order. Let's celebrate a little, because candidly, we don't get enough good news around here, do we? So today, let's spend a few minutes and let's talk about down goes ATF's pistol brace rule. Okay, this is what we are talking about, America. We're talking about the case of Mock v. Garland. We have talked about Mock v. Garland many times. We've talked about a lot of cases that challenged ATF's rule on firearms with attached stabilizing braces, or what we came to call here the pistol brace rule. If you go all the way back in our time machine, you'll remember we were doing videos about the old Form 4999 and what the heck that was going to mean and everything. And it has been nothing but an absolute roller coaster ride. It appears to have come to an end for now. Now, as you know, this case did start in the United States District Court for the Northern District of Texas in the Fort Worth Division. There was a bunch of litigation that took place in the district court. It ultimately went up to the Fifth Circuit. They had ricocheted around there for a little bit, but got quickly kicked back down to the district court with orders by the Fifth Circuit to expedite the process. The court has done exactly that. As you know, there were motions for summary judgment that were filed by both sides. What a summary judgment basically says, for those of you who haven't geeked out on that before, is, hey, listen, we don't think there's really any issue as to the facts. We really don't think there's any issue as to the law. And since we can agree on the facts and the law, really the judge can go ahead and make a decision in favor of us right now without having to do a trial. Now, both sides had actually filed for that motion. The court here has granted the plaintiff's motion for summary judgment, which means Mock and the good folks at the Firearms Policy Coalition who brought you this litigation, links down below for you to show them some love, have won this lawsuit, which means the rule is now vacated, because the remedy here is one of vacatur, which is a fancy way of saying we're going to throw it into the trash bin of history. The order of the court is a short one. I like a one-page order. It reads as follows. This judgment is issued pursuant to Federal Rule of Civil Procedure 58A. This action came on for consideration by the court, and the issues having been duly considered and a decision duly rendered, it is ordered, adjudged, and decreed that 1. Plaintiff's motion for summary judgment on the grounds that the final rule violated the Administrative Procedure Act's procedural requirements because it was arbitrary and capricious and was not a logical outgrowth of the proposed rule is granted, and defendant's cross motion for summary judgment as to those claims is denied. 2. On these grounds, factoring criteria for firearms with attached stabilizing braces is hereby vacated. 3. The plaintiff's remaining claims are denied as moot. 4. All other relief not expressly granted herein is denied. And that is signed by Judge Reed O'Connor of the United States District Court. Now, what this means is that the lower court here, the district court, has said, hey, listen, we've looked at the facts. We've looked at the law. We don't think there's really any disputes. When we apply the law to the facts, one side clearly wins, and that side is Mr. Mock and the good folks at Firearms Policy Coalition. What that also means then is that the rule is hereby vacated, okay? Which means the rule cannot be enforced at the current time. Now, when I spoke to ATF at SHOT Show in January, and yes, I did have some very interesting conversations with them, I had multiple agents tell me that they were not currently enforcing any aspect of the pistol brace rule, and that was during the litigation that we were seeing in January. Is this the end of it? Well, I'd like to think that this is the end of it, but hell no, this is not the end of it, because you know right now the Department of Justice is completely crap in its pants and will be filing an appeal probably as early as Monday. That appeal, of course, will go to the Fifth Circuit, which is going to be akin to the United States government trying to throw rocks at the moon. The Fifth Circuit has definitely shown a propensity to rein in the administrative state, especially that of the ATF. They have by far been the most pro-Second Amendment of any of the divisions of the Court of Appeals that we have. And so things do not bode well for the United States government for the Fifth Circuit. Now, when things go sideways in the Fifth Circuit, then the United States government will be forced to apply for certiorari to the United States Supreme Court. And at that point, we're already a couple of years down the road. And the likelihood that if this Supreme Court maintains the same political makeup as it currently has, they will have no interest in accepting review. For all of you who happen to go ahead and do the amnesty registration, I do want you to know that that is all null and void. You did get a free tax stamp. You probably didn't need to. And of course, now you have informed the ATF of at least one firearm. So if ever there were to be some type of confiscation effort, we kind of know where they may start with that. The case, once again, is Mock v. Garland. We're going to link up the order down below. It's a short one so that you can geek out on it. And remember, we're going to put a link down below for the good folks at the Firearms Policy Coalition, who absolutely knocked one out of the park here so that all of you can show them some love. Maybe you got ideas for videos we should be doing here at Washington Gun Law. If you do, click on that link right there. Some of the best ideas we ever had weren't really our ideas. If you got any questions about this or anything else related to what's left of our Second Amendment rights, the contact information for Washington Gun Law is down below there in the description box. And then finally, and most importantly, let's remember, the part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.